Hello and welcome to Send Yes Leicester. Disability discrimination. What is disability discrimination? Who can bring a claim? Types of discrimination, the Send Tribunal for Disability Discrimination, and appealing a decision. What is disability discrimination? Claims of disability discrimination can be brought against public bodies such as early years settings, schools, colleges, and local authorities. If the claim against a school was successful, it might be ordered to arrange training for school staff, change school policies or guidance, provide extra tuition to make up for lost learning, provide a written apology, provide trips or other opportunities to make up for activities the child or young person may have missed, make reasonable adjustments to accommodate the pupil's disability, change the location of lessons or activities within the school. Where a child had been refused entry to an independent school in a manner that was discriminatory, the school could be ordered to admit the child or young person. Or if a child was permanently excluded and this was found to be discriminatory, the school could be ordered to readmit the child or young person. The following things cannot be ordered: financial compensation, physical alterations to school buildings, and the dismissal of a particular staff member. Who can bring a claim? Not all children or young people with special educational needs will be disabled, and not all disabled children or young people will have special educational needs. However, the vast majority are likely to fall under both legal definitions. A child or young person is disabled if they have a physical or mental impairment which has a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. See Section 6 of the Equality Act 2010. Substantial means more than minor or trivial, and long-term means lasting more than 1 year or likely to last more than 1 year. This is a wide definition and can cover physical or mental health problems, as well as conditions such as dyslexia or autism. Who can a claim be brought against? Early years settings, schools, colleges and local authorities have legal duties to prevent unlawful discrimination. They must ensure that they do not treat children and young people with disabilities less favourably than others. They also have a duty to make reasonable adjustments, to change what they do or were proposing to do to ensure a child or young person is not disadvantaged. This can include the provision of aids and services to support a child or young person. A claim of disability discrimination against a school of any type, whether state-funded or independent, or against a maintained nursery can be made to the first-tier tribunal, Special Educational Needs and Disability, or the SEND Tribunal. A claim against a private nursery, a further education college, or a local authority would need to be brought in the county court. SEND-ES only advises on cases which go to the SEND Tribunal. If you wish to bring a claim in the county court, you will need to seek advice from a solicitor. You may be able to get legal aid to cover the costs of this. See the link in the description below for the legal aid keycard. As a first step, you will need to work out what type of disability discrimination you believe has taken place. Types of disability discrimination. The Equality Act 2010 sets out a number of ways in which a pupil may be discriminated against because of disability. Unfavourable treatment arising from disability, direct discrimination, indirect discrimination, failure to make a reasonable adjustment, harassment, and victimisation. Unfavourable treatment arising from disability. When a school treats a pupil badly because of something connected to their disability, such as not allowing their assistance dog into the school or penalising them for needing time off for medical appointments, and the school does not have a good reason for doing so. Citizens' advice state: being treated unfavourably means you're worse off because of the way you've been treated, for example by being refused a service or disciplined at work. Unlike direct discrimination, there's no need to compare your situation with that of someone else. All you need to show is that you were treated unfavourably because of something to do with your disability. Direct discrimination: when the school treats the pupil worse than a non-disabled pupil in a similar situation because of their disability. Citizens' advice state: not all unfair treatment is unlawful discrimination under the Equality Act. It's only unlawful discrimination if you're treated differently because of a protected characteristic, disability. It doesn't matter if the person treating you differently didn't mean to discriminate against you, or if they didn't know they were discriminating. If someone treats you differently because of a protected characteristic, it's direct discrimination. Indirect discrimination: where a school has a particular policy or way of working that has a worse impact on disabled people compared to people who are not disabled. This is unlawful unless the organisation or employer is able to show that there is a good reason for the policy and it is proportionate. Citizens' advice states: indirect discrimination is when there's a practice, policy or rule which applies to everyone in the same way, but it has a worse effect on some people than others. The Equality Act says it puts you at a particular disadvantage. A practice, policy or rule can be formal or informal. It can be a one-off decision or a decision to do with something in the future. It includes things like arrangements, criteria, conditions, qualifications or provisions. Failure to make a reasonable adjustment: schools should make reasonable adjustments to accommodate pupils with disabilities. What is reasonable depends on the facts. The Equality and Human Rights Commission have published guidance on reasonable adjustments in schools which can help you to work this out. The link is in the description below. Citizens' advice states: adjustments only have to be made if it's reasonable to do so. What's a reasonable thing to ask for depends on things like your disability, how practical the changes are, if the change you ask for would overcome the disadvantage you and other disabled people experience, the size of the organisation, how much money and resources are available, the cost of making the changes, and if any changes have already been made. Harassment: when the pupil is treated by a staff member in a way that makes them feel humiliated, offended, or degraded. Citizens' advice states: the harassment you experience was discrimination under the Equality Act if both the following apply. You didn't want it to happen, and you were scared, humiliated, or offended, or the person was trying to make you feel that way. Harassment can include things like verbal abuse, bullying, jokes, making faces, and posting comments about you on social media. It also includes sexual harassment. Victimisation: when the pupil is treated badly because they or their parents have made a complaint of discrimination under the Equality Act 2010. Citizens' advice states: victimisation is when someone treats you badly or subjects you to a detriment because you complain about discrimination or help someone who has been the victim of discrimination. Because the Equality Act recognises you may be worried about complaining, you have extra legal protection when you complain about discrimination. Alliance for Inclusive Education, ALLFIE. The Alliance for Inclusive Education's website also has resources which relate to discrimination, including a report on education and training providers' duty to develop accessibility plans to address physical and other barriers to disabled pupils' learning. You can find the link in the description below. Things to consider before making a claim. It is very important that schools that discriminate against pupils with disabilities are held to account for their actions. The first step would be to make a formal complaint using the school's own complaints procedure. In your complaint, you should explain what type of disability discrimination you believe has taken place and what action you think the school should take to remedy it. If the complaint does not resolve matters, you could choose to escalate the complaint to the Department for Education and Ofsted, or you could decide to bring a claim to the first tier tribunal, Special Educational Needs and Disability, the SEN Tribunal. However, it is worth considering whether disability discrimination claim is the best path of action in your individual circumstances. Discrimination claims are backward-looking because they focus on a past event of discrimination rather than looking forward to what support is needed. While the SEN Tribunal can order reasonable adjustments to be made, if what you really want is for better support to be put in place for the child or young person, you might be better off considering what the school should be doing to help. Make an application for an education, health and care needs assessment, or trying to get your EHC plan changed so that it provides for more or better support. A discrimination claim is likely to have a negative impact on your relationship with the school. However, you may think it is important to bring the claim for a number of reasons. If your child has been excluded so that they can be readmitted to school, so that the school are held to account, so that they will not discriminate against any other children, and if it is a group of schools or a chain of academies, the claim will be against the whole group, meaning your claim could have a wider impact. If you decide to make a claim to the SEN Tribunal, you can find more information by clicking the link in the description box below. Procedure for disability discrimination claims. The SEN Tribunal can hear claims about disability discrimination by a school under the Equality Act 2010. The procedure is very similar to that of bringing an appeal about an EHC needs assessment or EHC plan, which is referred to as a SEN appeal. There are a few differences which are set out on the following slides. We would recommend reading this section as well as the sections on appealing to the SEN Tribunal in relation to SEN appeals. The SEN Tribunal has produced guidance on bringing a claim of disability discrimination against a school, which you can find in the description below. Procedure timetable. For claims about disability discrimination against a school, the claim must be heard by the SEN Tribunal within 6 months of the discrimination you are claiming about, or within 6 months of the most recent alleged act or omission if they have been continuing for a period of time. Appeals about disability discrimination generally have a 20-week timetable. SEN appeal timetables are intended to be only 12 to 16 weeks. If a pupil has been permanently excluded and the school's governing body has upheld the exclusion and the SEN Tribunal is being asked to order their reinstatement, the appeal is likely to be dealt with more quickly within 6 to 8 weeks of submitting your claim. Procedure: submitting the appeal form. There are different claim forms depending on whether the claim involves an exclusion or not, and whether the claim is being brought by a young person or a parent. Claim forms can be found on the SEN Tribunal site. See the link in the description below. If you are simultaneously making a SEN appeal and disability discrimination claim to the SEN Tribunal, you can request that they are consolidated so that they are heard at the same hearing. However, you will need to complete a separate form for each claim. You should explain the child or young person's disability, the discrimination complained of, and the remedy sought. Procedure: evidence needed. You will need copies of professional reports or other documents which help explain the disability in question. If there is a diagnosis of a particular condition, you must provide copies of documents showing this. You should submit this evidence with your claim form. You should also send a copy of your current EHC plan if you have one. And you should also send copies of any documents which might help the SEN Tribunal to understand what the disability discrimination claim is about. This could include correspondence, copies of documents sent from the school, or written statements from people who witnessed events. Procedure: once the appeal is registered, the registration letter should inform you of the hearing date, and individual case management directions decided by a tribunal chair, judge, on review of the papers. This may include a date for a telephone case management conference. The SEND tribunal should also send the parent or young person copies of an attendance form to return to tribunal and a request for changes form. Procedure: the hearing. Disability discrimination claims will be heard by 3-member panels. The school is very likely to be represented by a solicitor or a barrister because of the adversarial nature of the claim. We strongly recommend seeking advice about claims under the Equality Act 2010 as early as possible in the process. You may be eligible for legal aid. The panel will not normally make a decision on the day, but will send out a written judgment after the hearing. Procedure: appealing a SEND tribunal decision. You can only appeal against a SEND tribunal decision if they make an error of law. You cannot appeal just because you disagree with their findings. In disability discrimination claims, you could either appeal or request that the decision is set aside. You can read more about this on IPSI's website. The number of cases which are successfully set aside or appealed are relatively low. Note that for SEN appeals there is also the option to ask for the decision to be reviewed in light of a change of circumstances. This is not relevant for disability discrimination appeals because they deal only with past events rather than ongoing provision. If a parent or young person believes they have grounds to appeal or to ask that the decision is set aside or reviewed, they should seek legal advice. You may be able to get legal aid to cover the cost of this. Email us on info@sendiasleicester.org.uk. Call us on 0116 482 0870. Contact us on Facebook, which is Sendias Leicester, and you can also tweet us @SendiasL.